Okay, welcome everyone, and thank you again for joining us for another exciting episode of our four-part webinar series on Proposition 15. The election is now only 2 weeks away, and in the past 2 weeks, we have heard speakers provide an overview of California's current property tax system and some of the potential impacts of Proposition 15, including numerous potential unintended consequences. If you're registered for those webinars and you missed them, we have sent around links to watch those episodes at your convenience. If you cannot find those emails, please reach out to me at ben@caltax.org, and I'll be happy to forward the links to the videos for you. Today, our panelists will provide even more insight into Proposition 15, detailing some of the necessary changes required to implement the initiative and some of the other impacts on taxpayers and tax practitioners. Our first presenter for our webinar today will be someone who some of you may be very familiar with, Santa Clara County Assessor Larry Stone. He was first elected assessor in 1994 and overwhelmingly re-elected 5 times by the residents of Santa Clara County. And the State Board of Equalization has acknowledged his office as one of the best managed assessors operations in California. And we are also joined by some esteemed property tax attorneys who need no introduction, but I will introduce them. To start off, we have Charles, or Chuck Moll, who is a partner with McDermott, Will, and Emery, where his practice focuses on state and local tax, primarily concentrating on the resolution of tax controversies. He regularly appears before the various California tax authorities, including the State Board of Equalization, the California Franchise Tax Board, the California Department of Tax and Fee Administration, and the Office of Tax Appeals. Chuck's practice also includes tax matters in other states, as well as federal tax controversies, including representing clients in federal courts and at appellate hearings before the IRS. The next panelist that we have joining us today is Cris O'Neill, who is a shareholder at Greenberg, Traurig, where he focuses his practice on ad valorem property tax and assessment counseling and litigation. For over 25 years, he has represented taxpayers in a variety of different settings, including before County Assessment Appeals Board and the State Board of Equalization, the Superior Court, the California Courts of Appeal, and the California Supreme Court. Cris represents clients in a variety of industries, including healthcare, hospitality, entertainment and recreation, and energy and natural resources. We're also joined by Michael Lebeau, who is a partner at Bewley, Lassleben, and Miller, whose career has included positions with the Los Angeles County Assessor's Office, the California State Board of Equalization, as well as private practice. While at the State Board of Equalization, Michael represented the board in property tax appeals and drafted legal opinions regarding changes in ownership and valuation issues. Currently, Michael's practice focuses on property taxes, including valuation disputes before County Assessment Appeals Boards and the State Board of Equalization, and litigation of property tax disputes before the courts. And last but not least, we have Douglas Moe joining us. Doug is of counsel with Eversheds Sutherland and recognized nationally as a leading property tax advisor with more than 30 years of experience in tax law. Doug guides his clients in the dynamic and complex issues of state and local tax, and he has extensive experience in litigation of property tax matters. Doug is an attorney who has also passed the CPA exam and concentrates his work in the telecommunications, energy, transportation, and manufacturing industries. And with that, I think we are ready to move on to the video of Larry Stone.
Well, let me just start by saying that the California Assessors Association completed a comprehensive analysis of Prop 15 with only one question in mind, and that is, can the assessors implement it? And we spent a lot of time on it, had an independent consultant review our work. We've been working on this actually since the idea came up of a split roll before there's the first ballot measure or the second ballot measure. And we really asked assessors all over the state if a split roll passed. We didn't have the specific language of a Prop 15. Could we, what would be the costs in real dollars and in staff and the extra work that would be required? And then we quantified that in terms of costs. And then we asked the assessors if they could implement it. And they concluded that we cannot. It would be impossible, not difficult, but impossible for assessors to implement the provisions of Proposition 15 as it's written. And assessors avoid revenue issues. You know, we do not want to be perceived as revenue agents for local governments or schools. So we're careful about that. So the assessor's position is totally oriented to the operational and the implementation issues and problems. We've concluded that this ballot measure is so convoluted and so difficult and confusing that it would be impossible to implement and very costly in terms of litigation and other things to happen. So that's where we start. So what's wrong with it? I mean, what are the, I mean, I won't go into a great detail because there's so many things that are wrong with Proposition 15 that it would take me more than the time we have available to describe them. But first of all, they try to, the authors, if you will, try to exempt certain types of taxpayers. They usually do it for political reasons. So they say we're exempting small businesses. Sounds good, you know, because they want to make sure that, but small businesses, most small businesses would not be exempt because most small businesses don't own property. They lease property from tax-paying landlords. So, and they usually pay their taxes through what's called the triple net lease. So every tenant in the building pays their pro rata share of the property taxes due. So you've got a landlord that's owned a property for many years, has a very low assessed value because of Proposition 13. These tenants would get, you know, as much as 8, 9, 10 time increase overnight in their property taxes. So it would really crush a lot of small businesses. If you have to reassess the market value a property every few years, then basically you have to do an appraisal. An appraisal for residential properties is pretty simple, you know, unless it's, you know, a different kind of property. For commercial properties, the value of a commercial property is based upon the income it generates. So it's much more complex to do an appraisal. So we need rent rolls, we need vacancies, we need cap rates and so forth in order to determine, well, there's no real, you know, there's no comparables really for most commercial properties like there is for homes. And so it's a much more complex task and we need much more information. But basically, we would have to do an appraisal every 3 years on every property and get information that we only are entitled to get now if there's an appeal. Other than that, you know, or if we have a downturn, of course. So the workload would go up dramatically, the appeals would go up dramatically, and I doubt whether the state legislature is going to provide that money, particularly when they're facing such a budget crisis that they have now. So the proponents say, oh, you're just going to get all the money that you need to accomplish this. And you're going to do it in 18 months. I was speaking to a school district recently, and I said, you know, who are very interested in the increased revenue that's proposed. And I said, if I told you you had to double your classroom teachers in 18 months, and they couldn't be entry-level teachers, they'd have to be experienced teachers, could you do it? Well, of course not. Well, then don't ask the assessors to double their appraisal staff in a profession where that skill set doesn't exist in 18 months. Deals a lot with fair market value. Well, you know, with Proposition 13, assessors don't deal with fair market value except 2 times. One at new construction, the other at changes of ownership. After that, we don't know what, nor do we pay attention to the fair market value because it doesn't have any basis in the property tax system until there's a change of ownership or new construction. So they keep referring throughout this ballot measure of fair market value. The assessor would determine the fair market value. Well, I can't tell you the fair market value of any property in the county. In fact, I get the fair market value of my own home from you know, what's the outfit in Chicago that does that stuff. So they, you know, also says that if a property owner has less than 50 employees, then they would be excluded from the reassessment. Well, I can't tell you how many employees any business has in my county. We don't track that. And what happens if, and it's not only 50 employees, but it's 50 employees statewide. So what if a company has 5 employees in Santa Clara County, but 105 in LA County? I don't know how many employees there are even in my own county businesses, let alone spread out throughout the state. So you can see constant things that make it impossible. Assessment appeals would skyrocket. You know, last year we got 2,100 commercial appeals in Santa Clara County. That's fairly normal. During the Great Recession, when we had the collapse of property values, we got 12,000 appeals in 2009, 10,500 in 2010, 9,500 in 2011. So you get the trend there. We project conservatively in Santa Clara County, we'd get 25,000 appeals in the first year. There's no possible way that we could handle 25,000 appeals. In fact, during the Great Recession, when we had 12,000 appeals in 2009, what did we do? We transferred our appraisal resources, appraisers, over from enrolling new construction and changes of ownership, where the real money is for the schools and local government. We transferred those people over to defending appeals. So we were creating backlogs of real money in 2009, 10, and 11 in order to defend assessment appeals. And that was with 12,000 appeals. You can imagine what would happen with 25,000 appeals. The costs would go up dramatically, not just for the assessors, for county councils would have to hire more lawyers in order to defend these appeals. The controller, who allocates the property tax revenue to these various jurisdictions. The clerk of the board that handles the administration of assessment appeals. So tremendous costs would be incurred. And so, you know, it just doesn't make any sense. It's so convoluted because of all this, except, you know, Prop 13 was 44 words. And most of the work was done after that by the state legislature. And that took them 2 or 3 years to get that down. This thing is so convoluted and so long and so many exceptions, and leaving things up to the state legislature, to the local assessment appeals boards, to assessors, the State Board of Equalization, all of us not knowing what our role would be in the implementation, which is another problem. The proponents say, oh, you'll get all the money that you need in order to make this happen. Now, I would have to double my appraisal staff minimum. In my county, that's 50 new senior appraisers, not entry-level appraisers, but senior appraisers. Those people don't exist in the marketplace today. I have 5 vacant right now senior appraiser positions that I can't find anybody to hire. And it takes me 5 years to take an entry-level appraiser, college degree, and put that person in a position with experience and training that they can assess and appraise and assess shopping centers and office buildings. The ballot measure gives me 18 months. So I couldn't even find the people to do it. And if I could, it would take me 5 years in order to put them in a position that they could do this work that the ballot measure, demands. They do things differently in other states because they don't have near the same kind of property tax system. That's number one. And they don't do it as well. In many states, and I've talked to assessors in many states because I'm involved in the International Association of Assessing Officers, which is assessors from all over the country and indeed internationally. They have serious problems. It's kind of like, my wife got a traffic ticket and she was guilty. And she said, I'm gonna go to court. And I said, why? And she said, because I'm told if I go to court, even if I'm guilty, I'll get a reduction. Well, that's the way it works in many states. And California assessors, by the way, are the high. I mean, I've been an elected official 42 years, 25 of that as the assessor. I began my career on Wall Street many years ago. I've been in the private sector for many years in the real estate investment and development business. The assessors in this state are the highest level of integrity and competence of any place I've ever worked in my entire career. You don't see that in other states. They make deals. You just go to an assessment appeals board. I mean, in Dallas, they have, multiple assessment appeals boards working 8 hours a day, 7 days a week, because the system's not that is good. So when a California assessor says, this is a value we've got a basis for that. It's not put your finger to the wind and guess what it is. We used to have an ad valorem system here for, before Proposition 13, and it wasn't very well, done either. Not periodic assessment. Proposition 15 says that all commercial properties must be reassessed to market value every 3 years. Why every 3 years? In order to spread the workload. So what happens if a property gets reassessed to market value in year number 1? And in year 2, the Great Recession comes along. And property values, as they did in 2008, 9, and 10, drops 50% in some geographic areas of our county. Is that commercial property owner going to sit there with an assessed value determined at market value in year number 1 and watch the value of his property go down by 50% and say, well, I'm just going to wait until after year 3 and then we're going to go through this again? Of course not. So the value of spreading this over 3 years in a downturn, like around here, the dot-com bust, or then the Great Recession, and now the COVID recession, no. So we would have to be reassessing that, as we do now when we have a recession. So the benefit of spreading this over 3 years wouldn't exist. And everybody knows we have downturns, we have recessions periodically. And so reducing the workload would just increase the workload for assessors. One of the reasons this will fail is because of the tremendous impact upon small businesses that the proponents claim are exempt or excluded when they're not. During a COVID crisis, where many small businesses are on the brink of collapse, and right now, the last thing you want to do during this kind of an environment is create tremendous increases in property taxes for small businesses that can't afford to pay the property tax they have now.
All right, and for everyone who hasn't joined us yet for our webinars, these are just a couple pulse checks that we'll have throughout the series, just to make sure everyone is awake. And for those wondering, answer D is the correct answer. Okay, and with that, I think we're ready to turn it over to our panel for their discussion on some of the impacts on practitioners and taxpayers and the Board of Equalization.
Ben, I'm going to suggest that we skip this first slide.
Okay.
Really, this is just a very basic introduction, and I want to say this, that I want to thank Assessor Stone for doing this video for us. And I will say it's rare that I can say this. I actually agree with much of what he said, but not all. Moving to the next slide again. I know there was some discussion last week that covered some of this, but I think some of the highlights that probably maybe weren't touched on. There is, if you look under the excluded section, talks about realty use for commercial agricultural production. Of course, that only applies to the land. It doesn't apply to structures and fixtures. So it's not really all commercial, and that's why the ag community is sort of up in arms about this. And I think that and this is what Larry Stone mentioned at the very bottom, the small business exemption. holding less than 3 million of commercial realty statewide. It's not on a parcel by parcel basis. You take all the commercial property owned by, you know, the entity and related parties and see if it comes up to 3 million. And that's, you know, of course, even deciding, is it even worth, if there's even one parcel, is it worth 3 million? Is it 2.9? Is it 3.1? Does it fall in the exemption? I mean, it's just, it really is not a very satisfactory exemption.
Chuck, let me jump in here and ask, because I think we've all realized there's a lot of ambiguity in the proposition, and then a lot of definitions that we just don't have. I mean, I think last week they were also talking about, well, what is a residential property? Is a dormitory at the University of Southern California that's operated by a private company, is that a residential property? And since we've got a lot of lawyers here, do we as in the bar see that there are going to be a number of lawsuits that will be filed immediately? Do we think there may be even lawsuits to bar some of the implementation of this? I haven't heard a lot, but I think as attorneys we may see those kinds of issues already. Have any of the other attorneys here on the panel heard about that or thought about that? I see definitional lawsuits almost immediately, because I think applications are going to be impossible on some of these and some large swaths of property for sure. So,
Yeah, I mean, I think obviously there's so much that's uncertain in the definitions and even how they should apply. I mean, there'll be a numerous challenges. Now, you know, unlike other states where, and Larry Stone said they have all these assessment appeals board in Texas. Well, California is the only state, there may be one other, that actually requires you to go to an assessment appeals board. Most of the states, you can get a trial de novo in court, and so you can see court challenges right away elsewhere. You won't see them here, court challenges right away, because you got to go through the AAB. And if there's no deadline on when they, you know, when they can get to your case, it'd be like New York, where you file something in court and 7 years later you might have a hearing. So who knows how quickly these challenges actually get to a judge.
Mm-hmm.
yeah.
You know, maybe that's should be part of the implementing legislation, is some way to get judicial relief on definitional questions, because Chuck does make a good point about exhaustion of administrative remedies. So, you know, we were talking right before the webinar that, you know, there are very few words in Proposition 15 that actually deal with what we're interested in. And so the real fight is going to be, if Prop 15 passes, you know, that implementing legislation is going to be probably a 2-year cat fight.
Yeah. Yeah, good point. Why don't we switch to the next slide, unless there's any other comments on this one from the panel. So this next one also is sort of a misnomer. It says full exemption of personal property and fixtures for qualifying small business of 50 or less California employees, except that there are 3 requirements you have to meet in order to meet that. And one of the most important ones, you have to own California real property as part of your business. Well, if you are where most small businesses are lessees, they don't qualify for this. Regardless of how few employees they have. So it's really sort of a, it is a smoke and mirrors, as one group said, to say small business, then basically, but small businesses mostly won't qualify. And of course, it doesn't come in, the exemption, I think, doesn't even come in for what, 2 years, 3 years, I guess it's 3 years. So it's a carrot that's a pretty small carrot.
And it creates another definitional question, Chuck. The question is, I have a fixture here in my office. Does that count as California real property enough that I'm going to get the exemption? So
that's a great question. That's a great point.
Brings up a whole nother problem. Will we be able to expand it to more people than maybe they thought that would get it?
Yeah. That's a great point. The bottom bullet point, I think, is one that people should keep in mind, is that it's not just the taxpayer, but it's any affiliates. And it's a pretty vague definition. Well, who's an affiliate? Is it relatives? Is it, or is it just corporate entities? Is it some other kind of entity? And, if you have a 1% partner in your partnership and they happen to own real property, or in a partnership that owns real property someplace else in the state, does that, they get aggregate all that in? I mean, it's really, it just makes the pool of businesses that actually would be eligible for some of these carrots that are being thrown out just smaller and smaller. And then of course fights about who qualifies and who doesn't. Let's go to the next slide. So this is, and this is something I think that Larry Stone talked about as well. And I think that this panel has lots of thoughts about. I will say one thing that we didn't put in here, but I think it really is an important, one of the benefits of Prop 13 is sort of stabilization of budget projections for local, government entities. And, because even Larry said if there's a recession of 30%, people will flood the Assessment Appeals Board. That may be true, but on the other hand, people who have held their property for a long period of time, a 30% downturn in the fair market value may not affect their taxes at all, because maybe their base year value is well below that threshold. And so what we find even during the Great Recession, most counties' budgets actually increased year over year, notwithstanding the Great Recession, because of the way Prop 13 is a stabilizing impact. Therefore, budgets are predictable. If you have something like this, it's based on fair market value. Well, everyone knows in California real estate is very cyclical. So you'll have boom years and they'll have bust years. And the politicians don't ever budget for bust years. They got money coming in, let's set up new programs, and suddenly the next year they want money to pay for it. So that's one of the, I think, severe unintended consequences of this. But there's plenty on here, and I know that each of you have comments you want to say about these various things.
Yeah, Chuck, one thing that we haven't had to deal with since the 70s and the 60s is the idea of rolling assessments like they had in Los Angeles County, back in the day when your value changed once every 4 years. And Larry Stone raised a good point. What if this is implemented and then you go into a sharp recession, but you don't qualify for 4 years or 3 years because the rolling assessment hasn't come through your part of the county, and will you be able to file an appeal? I think that these kinds of questions we haven't had to deal with in 40 years, and taxpayers are going to be kind of at a loss about how do we do this? Whereas if you're in Connecticut or other states in the union, this is kind of, you commonly deal with this. This is going to be a whole new field for us to deal with as well in these rolling assessments, because we know no county is going to implement changes annually. They just don't have the manpower.
Absolutely correct. It's absolutely correct. And Larry made that point, I thought, quite well. I mean, we've all, I know in our practice, we regularly hire appraisers, and the appraisers themselves, the appraisal firms themselves, in some sense, are hollowed out, and that as the senior people retire, there aren't a lot of young people coming up behind them, picking up the mantle, and so it's not just the counties that would suffer in that regard. It's also taxpayers, but it'd be an impossible void to fill, I believe. One point I would make about the unintended is this side effects is this elimination of new construction exclusions, because new construction will no longer count except for for residential homes. And there are a lot of what people think of as exemptions that aren't really exemptions at all. They are exclusions from the definition of new construction, such as seismic retrofits, handicapped retrofits, fire safety, ingress, egress. I mean, those things would suddenly they would be the value would be picked up in the new tax world. And so people haven't thought about that. The solar exclusion, the industry jumped on that right away and got a backup statute that will go into play if Prop 15 passes. But assessors have already said that's unconstitutional. They can't do it, and they will certainly challenge that. And then we talked a little bit about, before we started, some of these appeal processes. I know, Doug, you've got some thoughts on some of the bad things that Prop 13 does to people who want to appeal their property.
Yeah, well, we all swim in that pond with the, assessment appeals boards. And later on, we had got a bunch of slides where we talk about it in more detail. But really, one of the hidden things about Prop 15 that, the public will never really be sensitized to, is these procedural changes are just as profound as the split roll. I mean, the procedural changes that are summarized in a couple bullet points here, which we will talk about in great depth later, they are as seismic as the split roll. I mean, to take away the few coveted taxpayer protections that we have is going to make the playing field completely tilted in the assessor side. And I must say that was not an accident.
So with that teaser, we'll get to that in a minute, but why don't we switch to the next slide and keep moving through? I know we've got a little bit of a time crunch. So does someone want to jump in on this slide? There's going to be, we talked about the financial impacts upon government entities, but there's also, obviously financial impacts upon, businesses, projections, and whatnot. And this is what sort of explains that. Does anyone have a thought they want to jump in on this slide? If not, we'll move on to the next one.
Actually, why don't I jump in for just 1 second, Chuck? On this particular slide, one of the considerations about people who do not have pass-throughs on their leases, who are absorbing all of the property taxes, if they have those properties encumbered with a below market lease, they're looking at a major cash flow crunch on that property because they won't be able to pass it through. I mean, as we've mentioned earlier, most commercial industrial property is on a triple net basis. Mm-hmm. The small office I rent through here in Orange County is on a triple net basis. I'm paying for everything except for maintenance for most of the things, and everything else is getting passed through back to me. So every landlord needs to go through and make sure that they've anticipated whether they'll be able to pass this through to their tenants. And if they don't, they're going to need to be able to reassess the rents that they charge in order to be able to pass it through indirectly. It's a major consideration that they're just not ready for.
Yeah,
Mike,
go ahead.
Mike, let me jump in on that. The other possibility here is that the market will change, and that because we know there are certain markets, for example, a medical office, where they're already gross lease. In many places, they're gross lease already, and it's possible that there will be a groundswell of opposition from tenants in all different types of properties. And we'll move from California, which is primarily a triple net lease kind of jurisdiction, to a jurisdiction which is going to be much more of a gross lease jurisdiction. And I mean, I don't know how all that will work out. That could be huge. Yeah. And I kind of think that the people who wrote this thought, well, who cares about triple net, because the market's going to change. They're all going to become gross leases, and then the landlords are going to get hit. And we have to wait and see, but I think that's a possibility.
Mm-hmm.
Yeah, that's a good point too, Chris. And particularly for those, I mean, not all landlords are big national corporations that own high rises around the country. I mean, even in San Francisco, you get a lot of small buildings that are owned by, a family that maybe they bought it many years ago. And, the families comprise of, firefighters these days or other people, and they're, none of them have a whole lot of money. And suddenly if they've got to absorb, if they don't have triple net leases and they got to absorb, the costs of a big property tax increase, because last time they were reassessed was in 1976. They're going to have mortgage obligations and other, financial obligations they may not be able to meet, and that'll cause a further sort of cratering of, sort of real estate values and have other, adverse consequences. So that's a good point. Everyone's focused on the tenants, but landlords are going to have a problem, and no one, I guess people don't. They assume that people in California don't care about the large landlords, but there's a lot of landlords that aren't, large.
Yeah. Chuck, there's something else that kind of occurred to me when you guys were talking about this is I think all the landlords are going to be scrambling to review their pass-through clauses because some of them will be limited by change in ownership, right? I mean, a lot of people after Prop 13 pass goes, oh, we need to get a change in ownership provision in here so that we can pass through the increase in a change in ownership. It's not been contemplated for split roll. So if they raise your taxes based on split roll, the landlord might be stuck.
Yeah, that's a really good question because a lot of leases have a clause that will say that any property tax increase due to a reassessment under Prop 13, a change in
Yes.
ownership, particularly,
Yes.
cannot be passed through, or only can pass through partially to the tenant. But now this will be an increase in the value not due to a change in ownership, a change in law, and that may or may not be impacted by the lease. People will have to go and review their leases to see whether that's
exactly.
covered.
I'm actually working on a lease right now where we are writing into the lease what could happen on November 3rd or November 2nd.
Yeah.
There you go.
And when I negotiated my lease here in Orange County, I put in both change in ownership and a split roll expense stop on the property taxes, foreseeing what was happening right now.
I think it may be fair to say that another impact, maybe unintended impact of this, is a Fair Employment Act for property lawyers.
Commercial leasing attorneys.
But we're still against it.
We've got enough
okay,
work.
you want to move to the next slide? Mike, I think this is some of the things you want to
Yes,
talk about.
it is. I wanted to get an idea. I have a unique skill set. I've got 6 years with LA County, 5.5 years with LA County, 10 years with the State Board of Equalization. I've been in private practice since 2007. So one of the things I wanted to do was to try to figure out how is this going to affect the BOE, or back then in the 80s, we would have called it the SBE. So the first thing I did was I went to the board's website and did a search for the word change in ownership. And if you look at the middle of the page on the left side, 2,390 hits for change in ownership. So every time that popped up, 2,400 documents are going to require review. Probably 2,000 of them are going to be required to be either dropped or revised in response to split roll. So that just on a document by document basis at the BOE, this has a big impact. But this is just scratching the surface. Let's move to the next slide. The next slide shows a search for new construction. One of the earlier slides says we're not going to, all these rules about new construction and new construction exclusions are going to go away. There were 1,050 hits for new construction documents on the board's webpage. So between change in ownership and new construction, looking at 3,400 documents to review. Some are going to be just down, some is. And as we go, don't forget the supplemental setting or Article 13A. So potentially, if split roll passes, the whole supplemental roll system for commercial industrial property would go out the window. So we're looking at significant fundamental ground shaking events to affect the BOE. Let's go to the next slide.
Well, Mike, I think what you're making a case for is your
titled this
return.
Challenge to
No, it's
Sorry.
interested parties
that
will last until we all pass away.
Yeah, I was going to say that. We're going to be living at the BOE.
Yeah.
We'll be living at the BOE, or at least on the Zoom calls with the BOE if this COVID crisis continues for much longer.
Oh, goodness.
So I characterize this as a challenge to implement Prop 13. And the next slide's title, I think, says it all. It can't be underestimated. It is a fundamental change in what they do. In ownership, 2,300 documents, new construction over 1,000 documents. It impacts almost every BOE property tax program. The rules, the handbooks, the letters to the assessors, the guidelines, the annotations, the board prescribed forms. But some of the things that it also affects, a lot of people don't realize that the BOE has their finger in. And one of them is county appraiser training and certification, the legal entity ownership program, the state assessed properties program, and the assessment practices surveys. The BOE has a significant oversight function in all of what the county assessors do. Let's go to the next slide. I'm sorry, gentlemen, if you jump in, if you have any comments. I took a look at the regulations, at least on dealing with valuation and change in ownership. 20 through 29, all of the possessory interest rules, because you'll no longer be subject to to Prop 13, change in ownership reassessment for possessory interests. You've got the active solar energy programs and the assessment appeals process, the entire section 461 dealing with change in ownership, the entire series of 462 dealing with change in ownership, 463 dealing with the new construction, 474 dealing with the refineries. It is significant, and it goes even into their regulatory scheme, everything that's going to be affected. It also affects the handbooks. Section 401, change in ownership. Section 410, assessment of new construction. Basic appraisal, advanced appraisal, appraisal of personal property and fixtures, assessment of possessory interest, 510, 511, manufactured home parks, 513, shopping centers, 515, golf courses, cemeteries, open space properties. It touches everything. And don't forget the assessment appeals manuals, because of all the changes that are going to be to the assessment appeals process, along with the timber tax. You have BOE lines, annotations, interpreting all the guidelines, the county assessor certification and training course materials, and numerous BOE prescribed forms. Practically
Mike,
every form is going to get changed.
Mike, this is
And a lot of this, yes, Chris.
This is a tidal wave of
It
stuff.
is.
I've been involved with some of the BOE work that's gone on with, trying to respond to COVID, and then most lately dealing with remote hearings. I have not heard anybody, any staffer or any of the BOE members look ahead to all of this work that needs to be done. They don't have in my opinion, they don't have the manpower or any idea of what's coming. Have you? Talked with any BOE member or member staff, or has anybody about how they're going to deal with this? Is 5 years of work that's got to be done here.
It's 5 years of work and 2 years to do it, just as Larry was talking about. We're looking at just a fundamental shift in everything that they do.
I've spoken to
it's amazing.
Michael, just one quick, what I'm going to suggest. I've spoken to people at the BOE, and they don't have enough manpower to do a normal ruling request on a timely basis now. Never mind any of these things. And I'm going to make one comment. Then I'm going to suggest we skip a couple of slides to go to the what BOE can do. But this is. I mean, you're absolutely right, Michael. This is going to require significant changes in many publications and programs at BOE, and they're not going to know how to do it. And the problem is, if this is just the start, as proponents of Prop 15 has said, this is the first shot over the bow. We'll go after commercial, and then if this passes, we'll go after residential. They'll have to do it all over again and correct them all again when that one passes. But why don't we move to the slide about how the BOE will meet those challenges? I think that'll be quite helpful.
Actually, Chuck, I want to talk about one thing on the next slide, and then let's jump. The next slide, there is one thing: county appraiser certification and training. What a lot of people don't realize is that the State Board of Equalization is responsible for the certification of all the appraisers statewide and personal property appraisers. And they're responsible for training them all except for LA County. So the latest report on budgets and workloads published by the BOE is dated 2018. As of June 30th, 2017, there were 1,595 real property appraisers in the state certified by the BOE, and another 608 business property appraisers. So we're looking at roughly 2,200 people. You're going to be doubling that under Larry's estimate. So we're looking at doubling it from 2,200 to probably closer to 5,000. And all of these people are going to have to be certified by the BOE. And all of their training is going to be tracked by the BOE. So this is the one thing that the people don't see because it's so buried in their programs. So thank you for letting me address that one topic.
Sure.
How are they going to meet
a simplified a test? It'll be one question. Can you tell us what an appraisal is? If you can, then you're in. You're certified.
Well, you know, when to get a temporary cert issued by the BOE, all you need is a 4-year degree. That's it. And they'll give you a temporary cert on the spot.
Right.
It's good for a year, and then you have to take the exam. So, you know, there'll be lots of temporary certifications issued, but still someone's got to go through the 2,000 applications and filter through them to make sure that they qualify.
Yep.
Next slide. How are we going to meet these challenges? Need to update many books and handbooks, rules, regulations, certification and training. I'm probably going to have a technological answer, taking the exams online, distribution of revised publications. They've been pretty good about that they're going through using electronic distribution. But just as the county assessor is going to have major human resource issues, the BOE is going to as well. They do not have enough people to do their current job. Their institutional knowledge has gone away when the BOE was stripped out of all of those positions. Many of the people that did property tax work went to the other agency, especially in the legal department. So there's a lack of institutional knowledge on the legal side, and an agency that's been stripped of most of its resources that it needed to do its job. So I don't see an easy solution here.
And just to make a quick comment about that, you know, one of the, I mean, the title of this is schools and communities first, except that all these things you're talking about, all these expenses, all they're going to come up with, these all get paid first. And so the schools actually are last, you know, to any money that's left over, which will be very little, will go to schools. I mean, it all goes to the, you know, counties and expenses and then can be used for spending on any sort of, you know, item itself, and not just schools. So that's really, all these costs are going to really come home, would come home to roost. Why don't we go to the next slide? I think, Doug, this is, oh, it's a poll.
Yes, this is our second poll.
This is a trick question, right?
It is a trick question. It must be.
It is. Don't get it wrong.
Oh my goodness.
Those are the kind of questions we're going to have in the new certification programs, things like that.
Yeah.
That's right.
Actually, those who answer correctly are going to be put on the task force to implement all this.
Well, the question should be rephrased. The SBE will timely revise their publications within the 2-year period. True or false? Yeah, now we're getting the procedural changes, sort of my favorite part of this, the part that no one really realized until they actually read the text and then were horrified to see the procedural changes. My first reaction was A, they are worse than I expected, and B, it looked like Larry Stone wrote them. Somebody on the assessor side clearly wrote these and said, what are the 3 things that bug you the most? And then they put them in here. Next slide.
I've heard that said, by the way, Doug. So.
I think it's true. I mean, somebody came up with that list and it wasn't me.
Well, you know, what happened was that the first iteration of this was not going well with the Assessors Association. They were saying we can't do it. So they threw in these sweeteners, say, well, now will you support it? And it still, even with all these sweeteners, it wasn't good enough to get Larry and the Assessors Association to back it.
Wonderful.
But now we're stuck with these sweeteners.
Wonderful. Yeah, the first one here is a real crippling one for practitioners, which is right now there's a 2-year statute of limitations on a board to hear and decide an application. It's the only protection you have to make sure that a board actually hears your application. Without that protection, the board can just sit on your application and never schedule you for a hearing. And what this legislation does is it basically takes that away from you. And I was talking with Chuck before this seminar started, and trying to think about what kind of hammer can we come up with if we don't have the 2-year statute. And it's going to be very difficult to have anything to incent a board to hear our cases. So basically, you know, it could be 5-10 years before you get your case heard. Just impossible to deal with.
And Doug, go ahead, Chris.
Doug, let me jump in and say, sometimes it's not the board. Boards are sometimes diligent. It's the board is waiting for the assessor to say, okay, go ahead and schedule that case. So
Sure.
the assessor can actually hold you and hold you and hold you. And you're right, 5 or 10, I have cases now where they're 5 and 8 years, witnesses are gone, we can't find documents anymore, and the appeal is worthless because it's just been too long.
That's right. That's right.
So one of the suggestions I would make, we made a run at this, I don't know, probably it's going to be close to 15 years or so ago when I was, chair of the state bar tax section, is that California, unlike every other state, does not have trial de novo for property tax. And they don't have a 2-year limit in other states, but that's because you don't have to go to the Assessment Appeals Board and let it sit forever and ever. You can go to court whenever you want. And so if they're going to get rid of this, then we should get rid of the section that says we can't have a trial de novo. Every other state tax in California gets trial de novo. This should as well if we're not going to have a 2-year protection.
Sure. But of course, Chuck, they anticipated that and said that, substantial evidence. And so it's basically forcing you to go to the board. So
Yeah.
Understood.
All right, next slide.
I think we covered this one.
Oh, yeah, burden of proof. I mean, I'll be cynical here. I actually don't think burden of proof matters as much. I mean, when you walk in, it's going to be your burden, whether it says so or not. I mean, even if they say it's the assessor's burden, I mean, when they decide, the board's going to decide on who they want to give it to. They're not, I don't think there are cases decided on burden. I think it's always based on what the board wants to do. I mean, am I being too cynical here?
So, let me jump in and present the other side to it, Doug. And that is, I've actually had to sit through homeowner cases and watch homeowners come in, and a homeowner will show up with 4 photographs and say, well, this is what my case is about. Well, it's owner occupied, Mr. Assessor, it's your job to show us why. And then the taxpayer comes and says, well, I got 4 photos, and the board says, well, that's okay. It really doesn't matter because the assessor hasn't made his case. And I think I think homeowners will lose every case. And I think that, if you do personal property, escape assessments and being able to fight, I have 1 cases on a big escape assessment cases for personal property where the assessor basically had diddly in the file and came and presented it, and there was nothing there. And the board said, hey, escape assessment, Mr. Assessor, you had the burden, you didn't meet it, you lose. So I think for personal property, and I think for the homeowner cases, it's going to have a big impact. And it'll be easy now for a hearing officer to say, you brought 4 photos, that's not enough, bye. And homeowners, they don't know. You've got to come in with 4 comps and the time frame, and they've got to be beautiful. And homeowners aren't going to know, and they're going to lose.
True.
Let me raise 3 other points, I think, Doug, in situations where I think it's important. One is raise letters, where the assessor can decide they're going to try to seek an increase. Well, I've had so many times where, the assessor wants to seek an increase, but they don't because they don't want to make it their burden of proof. So they just say, we're just going to defend the roll value rather than go into a higher number. I think that's an important thing. The second is, what about the purchase price presumption? If you have a sale and the assessor wants to ignore the sale price, well, it's his burden of proof. But now, is that now gone? Is it now not his burden of proof? It's your burden of proof to prove your sale price is appropriate. That would be a terrible thing. And finally, I do think that the escape assessments, we just had a case that we won because it was their burden of proof and they didn't prove. In fact, the board said, they were sort of shocked at how little work the assessor did in trying. They just picked up some names in an account and said, this must be assessable. They didn't try to figure out what they were. They didn't do any work, and the board was shocked at that. And we got the Court of Appeals to go along with that because there was clear that they didn't do their job. So,
exactly.
You're right that oftentimes it doesn't matter, and it's really who has the better case. But there are times where you got to hold their feet to the fire, including as Cris said, I think the homeowner. So I think it's it may not be as, it may not have as practical effect as the 2-year statute, but I think it's an important one.
Okay, fair enough. Next point. This is the one. I think for people that don't practice, this one is like, okay, well, so what? Oh my God, this is the worst one of all of them. And I guess, on the last slide about burden and in this one, I'm speaking more as a practitioner and more complicated appeals. Just think about it. You're dealing with a $1 billion assessment, like Cris, like a refinery, or I'm doing a telecommunications facility, Chuck, you're doing a huge warehouse or something. It's got a lot of moving parts to it. Right now, if the assessor issues an escapement assessment, you've got 60 days to appeal it. So if these implementing guidelines are put in place that require that you submit your appraisal with your appeal application, how are you possibly going to get an appraisal done in 60 days? Not possible.
Even worse, Doug, if we're now, the assessor has a new fair market value every year, they send out their notice of, you don't know what the fair market value is going to be for this year. They send it out in August, middle of August, and saying, we've just tripled your assessment. You've got to file an appeal by September 15th in those counties, which is almost every county, or at least the counties that send out those notices. And you're going to get an appraisal done in that time frame? You find an appraiser because there's not going to be appraisers around to do it.
You're going to attach this to the assessment application, except for a refinery.
Exactly.
It's two of these.
No chance you get that prepared.
And the assessment appeals board have said they don't want this stuff. Don't send it.
Right. Oh, not only that, I'm sure the implementing legislation will say that if you don't tender it, you'll be precluded from introducing any additional evidence.
Right.
We might as well just move out of the state,
And here's another problem. You submit your appraisal information. Does the assessment appeals board have to look at it and see if it's adequate at the time you submit it? Who's going to know whether it's adequate or not?
Yeah.
That's going to have to be in there too.
There'll be a fight, 3 years later when the board decides to get to your case, they'll they'll say, well, it wasn't adequate, therefore dismiss this based on that basis, and they'll dismiss it.
Finally, let me go back to the poor homeowner who's standing there at the counter on the last day filling out the form. And then the clerk says, do you have your evidence? And they say 3 photos and pull it to the back.
Right.
They show it to you on the iPhone.
And then they say, well, where's your information? Like, where's your income approach? And the poor taxpayer who owns the fourplex is going to say, what's an income approach?
Right.
How am I supposed to know that? Well, I'm sorry, but sir, we can't accept your application because you don't have any appraisal data to attach to it. Your application is denied before it's filed.
Yes.
This is ridiculous. This is ridiculous.
Yeah. And then just think about this, Chuck, tactically speaking, because, we always enjoy the gamesmanship of assessment appeals. The assessor is going to have your appraisal to study for 5 years. Okay. You tender it with your appeal application. The board doesn't get around it for 5 years. They're looking at it for 5 years.
Right.
Not fair. They're not required to give you anything back.
Of course, it'll take them 5 years to find an appraiser to look at it because according to Larry, they won't have people look at these cases.
This is insanity. This part.
Can we go to the next slide here? I think yeah, there we go. Let's take a look at that. Can we go back just that last one, just on a check real quick? Just prior, let's see. Yeah. Okay. Yeah. We went over these points. Okay. Yeah.
Yeah, 60 days. Just, I'll tell you a practical point. I was talking with some clients about Prop 15, and I said, what I think we should do is we should start doing our appraisals in advance, because if they're really going to impose anything like this, to be safe, we're going to want to tender the appraisal with the application. So if you have any thought that there might be an appeal appropriate, start now, because you won't be able to start when you get the value.
Right.
That's true.
Yeah.
All right, next slide. Well, this is anticipating Chuck's point. So this is actually something that we live with now, which is, substantial evidence standard for questions of fact, de novo for questions of law. They have, you got to help me out here. Obviously, this is existing law, but they put it in the Constitution. And my guess is that the reason why they've done this is so we can't change it statutorily. That's my only speculation here. Is there any other reason why they would do this?
No, and I've heard that said before also, Doug, by others.
Okay. Yeah. It's obviously casting in concrete something that we live with now. And it's a very unfortunate standard for most taxpayers, because sometimes the boards aren't really interested in your case, they can really screw you on the findings of fact, and you can't change that. It's something you have to live with.
So there's a couple of things that's absolutely true, and this is probably unconstitutional. I mean, these boards are not in the judicial branch, and so the judicial branch has the right to determine whether something's legal or not, and so it's probably unconstitutional. It's certainly, like the Chicago case we mentioned earlier, it certainly should give you the right to go to federal court because you have no right to go to state court. And maybe going to federal court be a good thing rather than some of these local courts.
Well, you just gave me a great idea. We'll just expand the 4R Act to all taxpayers in California.
That's a great idea.
Then we'll be all set.
The way this is worded, I did like that it says including valuation, and it's not a defined term. And certainly one of our strongest ways to get a legal de novo review is to argue that you have an illegal valuation method. I can just see the taxing authorities will say, well, valuation means valuation method. That issue is going to be reviewed substantial evidence. And you say, well, that's not what everything else says. And they'll say, but this is now the Constitution. The Constitution, we've been told by the voters what valuation is. That will kill us. That will kill us.
And Chris, that's exactly what my point was aimed at. I was actually anticipating that that's what they were going to say, is that if it's a challenge to a methodology, they would say, no, it's valuation, and therefore you have no right to challenge it, even if it's a question of law.
Yeah.
That's what I've interpreted that, and maybe I was being too pessimistic, but that's how I was interpreting that part of the provision.
Yeah.
That's a tough one.
Yeah, all our cases will become factual only. Oh yeah.
All right. Yeah, I think we've covered this point.
Yeah.
All right, now it's time for our final poll question.
This is probably what we wish it would be.
And we do have time for some questions, and I do see that one has already come in. So I'll begin with this one. It says, if Prop 15 passes, will the Prop 13 definitions of change in ownership continue to apply for purposes of applying transfer tax to commercial property? For example, will transfer tax be due on the creation of a possessory interest or long-term lease, changes in ownership of legal entities, etc.?
That's a very good question. I think the answer, well, first of all, you'll still have change in ownerships, for residential until they do the other shoe drops and they get rid of Prop 13 altogether. I mean, if the statute is a Prop 13 programs and all the statutes they're under are taken out of the law, then there's a question as to whether or not these transfer tax ordinances that might rely upon particular statutes would still be, how you would apply that. But to the extent that you still have residential change in ownership, my guess is that the reference to the statute will still be, as valid as it ever was, not that it was ever really valid.
This is going to create a number of issues, Chuck, because the DTT statute stands separate from the property tax statute. And then in charter cities like San Francisco, which have created their own ordinances, which are robust ordinances, and in some cases may not even refer to the statute, or Santa County and its ordinances. Query: will this supersede those or not? I'm not sure, actually.
Yeah.
In the way that
go ahead.
In the way that the documentary transfer tax statute's written, it's imposed upon the writing creating the transfer. So if the Supreme Court is going to continue to maintain the position that the writing causing a Section 64D or Section 64C1 change in ownership is a transfer for purposes of DTT, I don't necessarily see a way around it.
Fair enough. I think it's unless there's a state law to change that, or if the localities change their wording, I think you're probably going to be stuck with our Supreme Court's interpretation for a while.
Okay, so we have some more questions now. Does the panel think assessors will stop adding LHI costs under audit and causing years of appeals, since they will presumably be assessing properties as if 100% finished at market value on a regular basis?
Well, the reason why so LHI are leasehold improvements, and the reason why this happens is because leasehold improvements that are fixtures are actually assessed by a different division. So the business property division in the assessor's offices assess personal property and fixtures. But other improvements, which are not fixtures, which are just improvements of buildings, and sometimes it's hard to tell the difference, that's assessed by the real property division. So you're still going to have two divisions which are assessing what they think are separate property, but in fact, there's oftentimes an overlap, and they both pick up the same property.
Mhm.
Yeah, I think that's going to
Mhm.
continue to be the case, and it's up to the taxpayer to, point out that way both sides of your office are picking up the same property. You got to take it out of one or the other.
Mhm. Yes.
And whether or not they qualify for the exemption.
Also, the question of when does a construction closeout occur? Since there won't be supplemental assessments, presumably, when construction is done, I guess it will get picked up in the next rolling assessment, which could be 2 or 3 years down the road.
Right?
Mhm.
Could be.
Yeah.
That
Yeah,
could be a benefit, I suppose.
Yeah, that could be a benefit there.
Yeah. Well, so but the law doesn't require that they can't do a reassessment every three. It just says at least within no more than 3 years can go by. They can do it every year if they want, or pick up instances when they want to do it. There's a new construction. Hey, we'll do it this year, even though we did it last year as well.
That seems arbitrary and capricious to me. Sorry.
All right, so our next question is, there's lots of doom and gloom today, which is probably correct, but is there any chance that counties get their act together and work to have a more efficient appeals process and resolve hearings in the same year, like Texas, where they reassess annually?
No.
I think that's an argument. That's a problem that if, it's like when statute limitations are changed, if there's a statute that's still open, that's subject to the new change. If it's closed, obviously, if your 2-year statute ends in December, or maybe argue at least before November 3rd, then it can't be reopened. But if it's still open, when the statute takes place, this part of the statute takes place, yeah, I think you can extend it anytime that it can be extended and or eviscerated. Sure.
Let me put a spin on this, and that is that with the advent of virtual hearings, some counties are chomping at the bit, as this is the way to get rid of the backlog, and forcing boards will force people into virtual hearings as fast as they can put them through. And maybe that'll be a good way to get rid of the small cases and the homeowner cases and so forth. So I don't think it's out of the question that the technology will be used to try to get rid of the backlogs of appeals and for sides. Boards will force both sides to virtual hearings as fast as they can.
Mm-hmm. Yeah, I mean, I was probably a little flip. I mean, in the small counties, they could potentially get on top of their workload. But if you're looking at the big counties like LA County, I mean, they are so slammed by COVID. They were slammed before COVID. And with COVID, it's impossible. So to say that you're going to get, hearing in the same year, oh my goodness. We never got a hearing in the same year with LA 20 years ago. I don't know why it would happen now.
Right.
Yeah.
LA, by the way, is one that's very much pushing virtual hearings as the way to remove the backlog.
Certainly. Yeah, I can see that.
They started virtual hearings this week, and they've issued extensive guidelines on those hearings on their website, on the board's website this week.
And I'm not certain that they're necessarily any faster. Maybe they are. Maybe there's less because you're introducing your stuff ahead of time. I'm not quite sure where the time savings come.
Yeah.
And how you determine someone's veracity when their face is covered by a mask and they look like a bandit. I mean, do you believe them or not?
Yes.
Or if they even bother to appear on camera, whereas one of the counties in San Diego, most of the assessors representatives are not showing up on camera during the Zoom. So how do you tell the veracity of somebody who you can't see?
It sounds like Star Chamber to me.
Fair enough. We have another question?
Yes, we
Oh
do. We have
my.
a few actually. So one was, if Prop 15 passes, will the 2-year statute still apply to prior year appeals that have?
Yeah, that's one we just answered. I think we said,
Okay.
I think our group consensus was it probably will, the
Mhm.
2-year statute will no longer apply to those that are open if this passes at the time the
Mhm.
statute becomes effective.
Perfect. So the next question that we have then is, some states do not assess personal property tax anymore. Do you think California may do the same in the future?
You know, I'd be curious to know what people on the panel think about this, because I know that there's
Yeah.
been discussion in the past that it takes so much resources to fight about so little revenue that maybe there's people have suggested doing away with it, but it comes down to this still does make some money. So I'm kind of pessimistic, but maybe this would be the time that would happen. What do you guys think?
I thought, Chuck, when I saw this, I thought this is the target and that's the next step. I mean, you've got a $500,000 exemption, so all the little ones go away. And we know, I mean, historically, you collect $1 on the personal property tax and it costs $1 to bring it in. And it doesn't make that much money. So I can see that that is still a possibility here. I see the impact of not collecting all of the $500,000 and less ones. It may be that it now does cost too much money to try to do it. I don't know. Well,
that would save some of the problem that Larry Stone was suggesting. They don't have enough. They can't hire people. All the people on the business property side now can just shift over and just do real property.
Yeah.
Not that they have any training to do it, but that hasn't stopped them before.
I think it's a good point, because I think we can let the assessors pick up that one. You know, they're going to figure out the same thing we're discussing. Let them carry that one, because we've got other fights. But I think the assessors might actually advance that and say, we need staff and we can redeploy if we can get rid of this where it's costing us too much money to administer.
Yeah, good point.
And the legislature has the power to do that because it's personal property.
Mm-hmm. That's right. They could exempt by statute.
So our next question is, are there any estimates of the potential increased need for property tax consultants, appraisers, attorneys for California if Proposition 15 passes?
I think we've already decided it's probably a full employment act for property tax lawyers, but Dick, does that mean you're going to leave in-house and go out on your own?
Maybe that's what Dick has in mind.
All right, and so we have one more question here. Will it be possible to restructure ownership to avoid reassessment under Prop 15, i.e. somehow reparcelize properties or separate ownership into many small separate real estate parcels or condos owned by different entities, which would all fall under the $3 million limit?
Well, my sense of that answer is there probably are ways on the margins to make some impacts, but because the related parties entity clause, it'll be difficult. I won't say it's impossible, but I think that the clever lawyers on this panel could probably help in some circumstances to achieve just that.
As long as they're right there on the margin at the $3 million number or lower.
Well, it could be, but there might be ways of separating ownership in a way that they're not carried over. I mean, it could be husband and wife. I mean, it depends on definitions are yet to come, but there might be ways.
Yes. So. Yeah, it's the attribution rules we're going to have to look at.
Exactly.
All right, I think we have time for one last question. It says, if this passes, won't the lawsuits that are sure to be filed put a stay on Prop 15 for at least a decade until the case is decided?
I'll venture my guess. My guess is they will not have a stay, that the counties will start implementing it, and generally for property tax, even if it's unconstitutional, you have to pay even while you're challenging it. I don't see that there's necessarily a mechanism unless we get into federal court somehow, but I think it's less likely than not that you could put a stay on this. What do you guys think?
Prop 13 was implemented.
Right.
And Northern River Hunt took place many, many years later. Was it 87, 88? So actually, no, it was the 90s. So I don't see a stay being implemented.
Mhm.
We have to deal with that. There's going to be a task force created pursuant to the proposition, and presumably that task force will be in session for two years minimum, maybe
Mhm.
because there'll be carryover tasks they can't get done. So yeah, I think that's very likely.
I think RV Han was 92 and Prop 13 passed in 78. So.
All right, and with that, thank you to all of our panelists for the great discussion today and for all of our attendees for joining us this afternoon for the third episode of our 4-part webinar series on Proposition 15. And we hope that you can all join us again next week for the final episode of our series titled Proposition 15, What Happens Next Week? The discussion next week will provide updates from the campaign on what polling numbers look like for Prop 15, what the funding looks like for the campaigns, both in support and opposition, and an update from the campaign looking ahead to the election the following week. And if anyone needs a copy of the slides, we will be providing those and through email. And with that, thank you all.
All right, thanks everybody for coming.
Thank you all.
Panelists, thanks.
Thank you.
Thank you, everybody.
Great work chatting with you on
Thank
this
you.
thing. It's a lot of fun. All right, take care.
You as well. Bye-bye.